Okay, well, welcome everyone to the second legal roundtable of the day today. I'm very excited to have one of our CVA corporate members, MME, host the legal roundtables. And Andreas Galarner is representing MME. He has been our returning Crypto Valley Conference speaker, and we're really excited to have you again. Always amazing content, always amazing insights that you're sharing with us. I will not take any of your time. Please introduce your panelists and have a great panel.
Yeah, thank you, Nikki, for the kind introduction. Hello, everybody. Big pleasure to be here again. Almost not opening, but being at the start of the Crypto Valley Conference 2022. You've already gone through a highly regulatory burdened panel with the travel rule before. We're not going to repeat the stuff you heard before on the travel rule today. What we're going to do is we're going to give you, or we'll try to do that, and that's also the reason why we have such a small panel, to really kind of go a bit deeper into questions related to DeFi and the applications of AML regulations in DeFi, as well as the give an outlook on MiCA and what that implies on DeFi topics. So I think we have a stellar panel today. We have Thomas, we have Marina, and I think I'll let you introduce yourself, Marina, if you would be so kind to start to tell a bit more about yourself and the European Crypto Initiative.
Of course. Thank you, Andreas. So my name is Marina. I'm coming from the European Crypto Initiative, which is a non-profit that is working on advocacy in Brussels, so on the EU level. We have been formed 2 years ago when basically MiCA, the Markets in Crypto Assets regulation, was issued as a draft from the European Commission. And when we saw this draft, we basically decided to step in and talk to the regulators, do education, and of course, try to understand how they think about regulating crypto assets, and, you know, trying to bring the best of our knowledge and understanding of the market so the regulation would be aligned. We're basically formed from the national organizations that were working prior to 2020. So you're probably aware in the EU, first when crypto was discussed on the national level, and then with MiCA, I think it was a very big milestone when we started this discussion on the EU level. So that's for the start. Thank you.
Thanks, Marina. Thomas.
My name is Thomas Nägele. I'm from Liechtenstein. I'm an attorney at law in Liechtenstein. Before that, I coded software for about 10 years. Was invited by the Liechtenstein government in 2016 to join a work group to think about regulation. We then, in that work group, drafted the Liechtenstein Blockchain Act, or it's actually called TVTG. And since then, I'm involved in some other jurisdictions where they think about regulation. We also had a lot of discussions with Europe about MiCA, and now we are focusing what would that bring Liechtenstein, and what's the connection between these two. And I'm really looking forward to our panel now.
Wonderful. So let's kick things off. Maybe to set the stage a bit first. When we talk about DeFi, the question is always, well, what is DeFi? What are we actually talking about? And I think looking in the practice, when it's a bit similar to the DAO discussion. People have totally different concepts what a DAO is. People have different concepts what DeFi is, how much decentralization is in the technology, and how much elements are actually more on a centralized level. And we just discussed that, 5 minutes ago, this comparison we quite often hear with a duck. If it looks like a duck and sounds like a duck, it is a duck. That may be accurate in many traditional models, but actually if you look at DeFi, you first need to take this duck apart, and you need to really screen into the duck to see how it actually works and to see whether it is a duck or if it's something else.
So we have to kill the duck first before we can tell you what it was.
Yeah, that's what the SEC does, right? No, but seriously, so I think the question on regulations being applicable in a DeFi setup largely depends what is inside a duck. So you can't just look at it from the outside. You really need to look into it and need to understand how the technology in this duck actually works and what are the money streams, what kind of control levels are centralized, if any, hopefully none, what kind of centralized elements are built into this duck. I think that's very important. And of course, in the discussion, the best cases for us advisors, and I think also from a policy-making perspective, if this duck is fully decentralized, so we don't have any central control, we don't have any central dependency, what I always refer to. As soon as you create dependencies in any form from a particular group of people, of individuals, then the duck actually may be a duck. But if this dependency is lacking, it may be something entirely different. And I think whenever you talk about regulations and implications and how to interpret those new types of regulations we're going to discuss about today, the key question is, well, do they actually apply in the context, yes or no? Or do we have someone who has this operational role in a DeFi setup, yes or no? So I think that was kind of to set the stage a bit on the discussion. Now, we have two key topics we would like to address. We have a lot of development in the DeFi regulatory space. We have on one hand, we have the FITF being very active. They've been starting to be active in starting 2018, providing draft and guidance on crypto asset, crypto kind of activities. The latest guidelines have been published in fall 21, that was, I think, which is now in rediscussions, and we're going to see in the coming months and years how they're going to be establishing. And then we have, of course, on the European level, the MiCA regulations, which we want to look at a bit further, what kind of implication that has. So the discussion is going to be split in two parts, mainly. First, AML regulation topic, WASP, what is a WASP? Second one is the MiCA, what is a CASP? That's the core topics on that. And we're going to have some questions, room for questions at the end, but please feel free to intervene and raise your hand whenever you have a particular question you want to ask at the moment, because we are kind of a nice room, a small group, so we can answer that hopefully and have time for those questions as well. Okay, to start with, it will be the WASP discussion. As we all know, we had FITF had this concept of a WASP, and we heard about that in the session before on the travel rule, that on WASP travel rules applies. We don't want to focus on travel rule today, but the core question to be answered is always, what is a WASP? What is it actually defined in the DeFi context? And from a FITF perspective, the terminology of a WASP is actually quite close to something which is somewhat a financial intermediary, as we know that under Swiss laws. And then the next question is, how do particular countries implement that definition into their local regulations? And I think to start off the conversation on that, we can look a bit at the Swiss example. Switzerland has implemented the WASP DeFi concept already in August 21. Let's see if that works. To start the discussion how it looks like in Switzerland. So basically what Switzerland has done, it has shifted the concept of what we call in Switzerland financial intermediary, which is kind of the WASP terminology in Switzerland, from someone who holds assets or controls assets of third parties. So that's a key element of a financial intermediary, as it was until August 21, that someone who has actually power of disposal over third-party assets will be qualified as financial intermediary, as a WASP, and then be subject to AML regulations. Now, in the path of implementing the FITF guidelines into Swiss law, which was made as part of an ordinance in 21, this concept has been shifted. And now the new concept is that if you provide tech infrastructure, so if you support peer-to-peer transactions in an ongoing business relationship, you would already also qualify as a financial intermediary. So it's no longer the precondition that you hold or control third-party funds. It's sufficient that your technology is being used in an ongoing business relationship to allow and facilitate peer-to-peer transactions. Now, the key question, of course, well, what does it actually mean in a DeFi context? What is an ongoing business relationship? What is facilitating peer-to-peer transactions? And unfortunately, we don't really have any court cases as of today because only courts can decide that. It's too early for that. But I think looking at the FITF model, it would still need to have a certain element of control or dependency that you actually are qualified as such a financial intermediary. And in particular, on business models, like if you look at an NFT marketplace where you have a transaction layer, peer-to-peer transaction layer built in, working on smart contracts like on OpenSea's, built by OpenSea in this example. The question is, well, would OpenSea qualify as a financial intermediary, yes or no? And that will highly depend on the level of control and dependency of the users of these smart contracts. And our view, but that's our view, and Fima may not share that, is if there's no dependency, so if there's no possibility to amend those smart contracts, if they're hard-coded, and if people just onboard without having accounts, they just onboard their Web3 wallets and kind of can leave at any time, there's neither an ongoing business relationship nor a dependency. That's why we're, at least myself, I'm of the opinion it's going to be hard to have those regulations apply in these cases. But I'm very curious to hear now from a Liechtenstein perspective how this financial intermediation VASP definition is being used in practice.
I mean, in Liechtenstein, as I said in the beginning, we have a specific law which is dealing with the crypto assets and crypto asset service providers, and they have to be registered with our financial market authority before they can provide the products and services. But that's for crypto assets, which is quite similar to the situation we are going to have on a European level. So we have one regulation which is applicable for the crypto asset space, and then we also talked a little bit about if someone is actually considered a financial intermediary. And that is in Liechtenstein because we are part of the European Economic Area, not part of the European Union, but part of the European Economic Area, is harmonized. So the European laws like MiFID, they're applicable in Liechtenstein. So what is a financial intermediary in the sense of these regulations, we cannot anyway change, right? That's given. And that's actually, maybe we have a second in the second part to not only talk about MiCA, but also what the European Commission drafted with this DLT MTF pilot regime, because that is actually that deals with the financial instruments in a tokenized way. So coming back to that question, we do know who are crypto asset service providers in Liechtenstein. They're basically the ones who are registered with our financial market authority to provide products and services. The thing is, when Liechtenstein last year then implemented this travel rule into our laws, the Liechtenstein Financial Market Authority approached the industry and said, let's discuss to find a way how we can actually do that, because we all know the challenges there. And now this was done in a way where they actually say, okay, if you are a local registered service provider based on our law, yes, you are a VASP. But also if you are a foreign company somewhere and you would be treated based on our regulation as a service provider based on our law, you are a VASP. And in addition to that, even if you are outside of our country and in the country where you are, travel rule would be applicable for you. We also treat you as a VASP. So basically, almost everybody, right? Like everybody who is providing services in that area, which we think should be regulated. And I think that is the first question we should ask. We briefly touched on what is like decentralized enough. How is it, like, where do we draw the line, right? I think the consequence should be not only if regulation is applicable, but if we should have a different set of regulation for a different way of organizing the same products and services, because that's DeFi, right? It's the same demand. Someone wants to buy a crypto assets or an equity, right? It's the same demand. I want to buy something and I want to get it. I want to have ownership of it, right? It's just the way how we organize it. It's not going to be via a centralized intermediary anymore. It's going to be maybe parts of it in a decentralized way. And then other regulatory, we should then use or check if we could use other regulatory approaches. And that is exactly what happened in Europe when it comes to the financial instruments. But that's one very small part. And then this now brings you to the situation we have in Liechtenstein since 17th of May. We have actually a quite similar situation as we have it in Switzerland, because the unhosted wallets, as we briefly discussed, they are also covered now with our guidance. It's basically the same situation.
Okay. And now, just before we move on to the European kind of FATF implementation status, what I would be curious, in the example I gave, you have this let's say OpenSea kind of style setup with a payment transaction layer on smart contract level, Web3 wallets connected to that. Now, I said in Switzerland, well, depending on the setup, you may or may not be subject to AML regulations, because you may or may not qualify as a WASP. So the details, when you look into the doc, really matter. How would that be in Liechtenstein?
As soon as you provide with these token transactions, right? Even if you do it in a decentralized way, you would be treated as being a service provider. The question there is, if you have someone to grab, right? So if you have someone, then it's not talking about the specific example you named the product, but like in general the concept, that would be the trigger, I think. The good thing is what we could do is, and we, as far as I know, I'm not aware of an example in Liechtenstein with such a marketplace at the moment which is operating, but we could actually go into a dialogue with our regulator to discuss that. Okay. Which I don't have an answer for you yet.
Yeah, no, I mean, it's just an example, but obviously this kind of payment layer on Web3 infrastructures, it's one of the key elements to most products, maybe in the marketplace, but also for many other applications. So it's going to be very decisive how the different countries are going to be applying their rules on those kind of setups. Marina, now on the EU level, do you happen to have an overview on implementation statuses in different jurisdictions of FATF recommendations or guidelines?
Yeah, so as I said before, the first to adopt certain rules were the national states. We know that France, for example, has done that, and they have a regulation on crypto assets, also on their AML laws. Just recently, I think two weeks ago, FATF issued a report on the whole status of AML regulation in France, and basically what they said there was also that the regulation when it comes to crypto is adequate, and that how they start in a way, if we talk about the travel rule, if we start from €0 on as a threshold for sharing the specific information, that was something that they found it was a good move. So this is also a very debated question at the moment on a transfer of funds regulation on the EU level. And if we discuss about VASPs or CASPs and the definition there, again, on the EU level, the answer is we don't know yet, because the VASP definition is basically adopted through the MiCA CASP definition, that means crypto as a service provider. So in the transfer of funds regulation, it says that the service providers are called crypto as a service providers, and they are defined in MiCA in order to align those two regulations, and basically that they mean the same as a VASP within the FATF documentation. So what is very interesting, because this is why I said we don't know yet, MiCA and the TFR are still in the process of being finalized. So just yesterday we had one meeting, a trilogue meeting on MiCA, which means that it's a big political meeting where all the three institutions, the Commission, the Parliament, and the Council meet, and they had discussed, we expect another one to be the last one within the French presidency, and after this one we'll have much more clarity what is going to be the final draft for MiCA. And so if I go back to the definition of how the CASP is defined, today we have three different drafts. Is the Commission one, the Parliament one, and the Council one. And so the first one was issued by the Commission. At the beginning, the definition was the crypto as a service provider is any legal person that exercises this specific activities. And so the activities can be custody, exchange, even advice, management portfolio, and stuff like that. So there are a few services that are defined. But what is important in this context when we talk about DeFi is basically what is the entity. And so when we look into the Council and the Parliament draft, they added entities. So it was not only legal person, but it was also natural persons and undertakings. And so those undertakings are probably meant as something that is decentralized, something that might not be registered, something that might resemble this decentralized autonomous organization, which is crucial for DeFi and which is crucial for the question how decentralized this project is, and basically a question in MiCA and also linked to TFR, are the decentralized organizations and DeFi included in the scope of MiCA?
And now that's the focus on MiCA, and we're certainly going to talk a bit more on MiCA a bit later on. But now looking at the EU AML package to be implemented, I think in a coming days almost, can you tell us about the status of that and what the focus will be?
Yeah, of course. So there is a new AML CTF package in the EU. It's composed of 4 different documents, and one of them is the transfer fund regulation that we discussed also that you discussed in the previous panel. And so this is the one that was that there were added some rules that are specific to crypto. Of course, there's other regulations. There is going to be an AML regulation that is basically there's going to be a new agency in the EU that is going to overlook the whole processes of AML, which is very important. And of course, there are new activities that are going to help the national financial authorities. And here, I think what was the most interesting part, especially if we talk about DeFi, was the unhosted wallet definition, and of course, the exchange of information between unhosted wallets or the service providers that provide unhosted wallets with other service providers. So what the TFR, I don't want to go too deep into that because you had a discussion before, but the most important thing is basically the rule is that there is going to be an exchange of information between crypto as a service providers that are, of course, within Europe, then the foreign crypto as a service providers with the European ones, which I think it's very important when privacy rules come into place here, and of course the unhosted wallets, as they're called, with crypto assets service providers. The peer-to-peer exchange between unhosted wallets, or as we call them, just wallets or personal wallets, are not regulated, are excluded from the regulation. That is in this draft, and for now, of course, we discussed before if we might expect something similar in the future, especially listening to some talks that European Central Bank board members like Panetta had in the last months. They also mentioned peer-to-peer regulation, so we don't know, we don't have more information about this.
Okay. So it does sound, to kind of sum up, that on the AML level, I think all Switzerland, Liechtenstein, as well as the EU, finally a part where EU automatically takes over Swiss law, are going to have the same type of regulations and the same level of standard, which would bring me to the assumption, but I don't know if you can answer the question, going back to our example on the OpenSea style marketplace with the transaction layer, that there is room that also in the EU, depending on the countries, that may not necessarily be subject to AML regulations.
I would say that the answer to that would be linked to the final draft of MiCA and the TFR, because there is a possibility that decentralized autonomous organizations or some of the DeFi applications might be excluded from the scope. And I have another question related to this. It's basically if the platforms will not be the ones that would need to be compliant with these rules, who are the service providers in the operation of those platforms that might need to be compliant, if there are some? What we have seen, especially the trends in the NFT platforms, I think just in few months, the trends changed dramatically. We have now even exchanges like Binance and Gemini offering NFTs, which means that they do KYC, is their standard procedure, and even the projects and the platforms that are open, they're trying to offer their users a very easy on and off ramp from fiat, so they don't basically need to use wallets if they don't want to, crypto wallets. So it's definitely going to be interesting to see how this will play in future.
I love the thought. Actually, it's going to be very interesting also on the asset side and the qualification of the NFT side, because what we see currently in the market, it is kind of having NFT equalizing with collectible art, that's one thing, of course, but if you look what's actually happening, I think NFT are more and more moving into kind of curated assets, which could at some point actually qualify as securities. I think that's a potential risk. So I think we heard a lot about AML regulations. I think I'd love to move forward to MiCA. You already made some comments on that, and you've also maybe I give that to you.
Yeah, thank you.
You can give us an overview what MiCA actually is. I think for especially people in Switzerland, we always kind of hear that and we kind of fear it a bit, but we don't really want to touch it too much. But I think we need to look at it more closely because as we're going to see today, it's going to affect Switzerland as well.
So what I can say that MiCA is coming, and when, I think this is a very important question for everyone working in this industry. So the political agreement, we expect it to be accepted by the end of the French presidency, and then by the end of the year, probably the final draft is going to be issued. And then depending on what draft is going to be applied, we'll have 9, I think, 18 or 24 months from the date that will be then applicable to for everyone to be compliant with. So we expect probably 2024 that MiCA will be the one that is going to rule crypto in Europe for the European service providers, but of course for service providers that are coming from Switzerland or from the US. So I have 2 slides very shortly just presenting what's happening in MiCA regarding DeFi, and those slides are a little bit subjective. It's basically, in a way, our organizational opinion on what we see as a drafts. So what is very important, as I said before, is the scope. Is DeFi or are all DeFi applications going to be within the scope of MiCA or not? I'm not saying DeFi is not going to be regulated. We have some international organizations like OECD, we have IOSCO and other organizations talking about DeFi and regulation, and we also expect something similar might happen in the future. The European Commission at the moment is also writing a report on DeFi and the basically infrastructure layer. So those are all, I would say, very interesting elements to see in the future. So as you see, that is a very important thing. And of course, like stablecoin regulation, this is also something that is why MiCA was adopted in the first place, because of Libra or Diem in a way. So this project does not exist anymore, but it is regulating stablecoins very, I would say, thoroughly. What we can see today is that the decentralized stablecoins are prohibited to be I would say, offered in the European Union, which can lead to a lot of different scenarios. You can just think about some decentralized stablecoins being delisted from exchanges in Europe, not being able to offer services that include decentralized stablecoins and similar. What is very important for DeFi also is that there is a prohibition of on interest. When we think about DeFi applications, a lot of DeFi applications do have interest as something that is a part of their business plan, so that's also very important. And going back to what I was saying about stablecoins, there are two types of stablecoins that MiCA is addressing. Some of asset reference tokens that are basically backed by crypto or a mix of crypto or other assets, and e-money tokens. So e-money tokens are something that is already, I think, quite known in the EU. So MiCA is referring to the e-money regulation. But when it comes to asset reference tokens, this is a new thing. And those tokens can have two different functions. One is the payment tokens, and one is used for, I would say, investment. So the payment tokens are the ones that are probably going to be also regulated in a more heavily way. And that's, again, to be seen how this is going to be developed and what is going to be the combination of the three drafts that we have today as a final draft of MiCA.
Okay, thank you. Well, and we all know European legislations tend to have a bit broader application and extend the principle of territoriality quite often. I think, Thomas, you gave that all thought from a Liechtenstein perspective, but maybe you can also start in a more general way to kind of what is the cross-border implication of MiCA?
I mean, first of all, don't forget about the good thing about MiCA would be that your services would be passportable again, right? So if you are then having a MiCA license and your company is incorporated in one of the European Union, European Economic Area countries, if it's going to be in the EEA agreement, which we all think it will, then you are incorporated in one jurisdiction, you get one license, you have to deal with one national, local regulator, and you can passport your services to all of Europe and EEA. And that's like, we all know the hassle we have today, that even if you set up in Switzerland or in Liechtenstein or in Germany or in Austria or wherever, you are licensed based on a local law which is only applicable in that respective jurisdiction, right? And you're locked in. And that completely will change when you have like a market in crypto assets regulation, which is applicable in a 400 million plus market. You can choose your jurisdiction and then you can passport your services. I think that is a huge, huge, huge benefit. We shouldn't forget about this MiCA thing, right? And I want to add there as well, I think when we talk about if a specific DeFi application should be exempted or included into such a regulation, I think the question should always be, what's the risk and why would we need regulation? And for me, the application of a DEX is a very good example. If you have a central exchange, right, what are the main risks? Just to give you an example, right? We all know if you operate a cryptocurrency exchange and you are in control of the order book, if there is an order book, you can do everything. You can do front running, you can have fake orders, you can do all of these things we don't have hopefully anymore in the more regulated financial industry because of regulation. Because what we do is we will check the intermediaries, they have to get licensed, they have to be fit and proper, they have to have mechanisms to avoid these things. We don't want to have fake orders because I want to have a transparent price and I want to have a fair price, I want to have a fair transaction, right? And now the promise is with decentralized exchanges, we use only technology to have the same result, right? And if that works and technology is working without anything else, we have the risks properly addressed, why would we then need a specific regulation? So I think that should be the angle, right? You should go 3 steps back and think about, okay, why do we have regulation? Why do we regulate intermediaries? And if technology works, right, then maybe have a specific regulation. And that brings me to, and I will just say one sentence about this DLT-MTF pilot regime. That is exactly what the European Commission did with that DLT-MTF pilot regime for the financial market in respective of financial instruments in a tokenized way. They basically said, okay, trading, as long as it is centralized, right, it's highly regulated. But the thing is, we will exempt, under certain circumstances, these service providers from using a CSDR, a central security depository, right? So we should have this kind of approach. And I think it's, in overall, right, we can discuss any detail about MiCA, but overall, it's not that bad, my personal opinion. So this brings me now to the question, what's the situation in Liechtenstein, and what is coming, or what influence will MiCA have on Liechtenstein? I mean, the Prime Minister of Liechtenstein said on an event on Tuesday that there were a lot of exchanges between Liechtenstein and the European Commission when they drafted MiCA, because they analyzed all the existing regulatory environments they had, right? That is pretty obvious. We were also invited in Brussels several times to have exchange of thoughts. This ended up in a somehow similar concept and like in a similar way of regulating intermediaries. And I think when you look at this, is just I issued that actually in October 2020 when the first draft of MiCA was available. It was published by the European Commission, just to check like what's the regulation level. And that's the only idea behind that slide. And why is that of importance? Because for our intermediaries in Liechtenstein, if you are regulated based on our law in Liechtenstein, you operate an exchange, for example, out of Liechtenstein, there is, and it was Article 123 in the initial draft, there was the possibility that if you are already regulated, when MiCA comes into force in your jurisdiction, you can switch your local registration or license into a MiCA license, right? So, like what I'm trying to say is, for us, yes, MiCA will be applicable, but it will also allow us out of Liechtenstein to address this 400 million plus market. So you can start in Liechtenstein with a kind of same regulation and hopefully opt then for MiCA. It's not perfect, right? It's a very comprehensive regulation, MiCA. But I think it's a good step into the right direction, because imagine you can actually now then address European clients out of one jurisdiction, be it Germany or wherever.
Yeah. And I mean, for me, when I look at the current, there was a question, apologies, yeah?
I think your approach to say we have a car and the advantages to have it regulated in all the different countries at the same time, it's a good approach, but if this car has no wheels. Hi, you stated that at least MiCA is a good regulation, all the regulation, because if you have a car and it's fully regulated in every country and you can exchange it, it's an advantage. But if the car has no wheels, it's a little bit a difficult topic. And at least if you see the MiCA regulation, if you see the DLT regulation, it's half of a banking license. And any project in the blockchain ecosystem who has a token needs liquidity, and the liquidity has to be provided. And if we really go then with and say this is a good topic and we are all fine with it, the law firms, everybody is fine with it, I would say it's not, because all the blockchain projects need the liquidity and the proper and fast exchange. And so my question is, my statement would be a little bit why the law firms are happy with it instead of law firms in the crypto space are not fighting like we do also with our legal team in MiCA for any possibility to come up to a more liberal environment, because blockchain was made for it.
Thank you, Guido. Maybe I just, actually, I think it's a very good point you raised. And it was going in the same direction. My comment was basically, so let me try to rephrase that. One of the current difficulties we see when we try to bridge DeFi with CeFi is that many of the license frameworks which are applicable, it's really difficult to fit the DeFi product in it, that it works and continues to work with the liquidity and the market exposure it needs. And we've seen that as well with DLT trading venue license. If you want to have an automated market maker, under a DLT trading venue license in Switzerland, it's not an easy exercise. So my question to both of you really is, and I think that meets a bit your
Maybe
concern.
Andreas, allow me to answer directly, because I think it was directly addressed after I said something about Mika. I said it's not perfect, right? But I said you should also focus on the good side of Mika. And I mean, we live in 2022, and that doesn't mean that we do everything on every level we can to have good regulation. In any lobbying possibility we have, we address our issues. And I said there are a lot of problems in Mika, right? Why should, like you being personal liable if you do a token emission, right? Like there are a lot of really big challenges in Mika. But we shouldn't forget about, yes, it's not perfect, right? But there are also good things about Mika, right? I'm not saying that it is perfect. And you can believe me that that there are a lot of, like, specifically, I am trying wherever I am, right, to lobby for as less regulation as somehow possible. You should only regulate if really, really needed, right? That was always our approach. If you have the possibility to lay technology, do the same, then don't regulate. Right? That is my take on that. Sorry, I just wanted to answer to that.
Fair enough. But now, I mean, my question really is to both of you. Now, if you look at this example for DEX you provided, and I think it's a really kind of easy example, automated market making can be made fully decentralized. How would you fit that, or could you potentially really fit that into a licensing regime of Mika, or is it, and how would that be done? To the way you could already say that today, of course.
I think, Marina, if you want to answer for Europe, I can answer for Liechtenstein.
Yeah, sure. So I would also address first the question, and then I would answer to your question. So the European Crypto Initiative was basically established for this, for lobby for the, I would say, decentralized use cases in a way. Our supporters are mainly layer 1 blockchains and some of the DeFi projects. So again, I think that the regulation is coming and we cannot avoid this. We're also welcoming Mika as a regulation, and as you said before, really bringing this European market as a one market, because right now we have few countries that are basically the big players that have regulation, and then some that have non-existing regulation. So that's not good for the projects, neither for the users. But at the same time, it's just because we have, with blockchain, we have for the first time in history an example of decentralized, it was, I would say, infrastructure, but also organizations around this. So of course, it's very, very hard to regulate this. And what we are trying to achieve is basically regulate, the most important things with Mika, of course, but when it is the time for regulating decentralized use cases, maybe take a slower path, take a little bit more time to understand, especially what are the technical equivalents that we can use, that blockchain brings, all the transparency, all the data that we have, available for everyone regarding the TFR, AML, and also for Mika, that we can use, and then, maybe have a specific regulation that, again, is very different from what we have been I would say taught in schools, but also what we have experienced in the past. Every time we have a regulation, there is a centralized entity that needs to be responsible and have obligations. And this is where this thing is specific and very different from what we have from before. So yeah, thank you for the comment, and I think that's quite important. When it comes to DEXs, I think it's a very hard question. And of course, as I said before, the crypto as a service providers that are operating exchanges are regulated under Mika. And again, it depends on the draft, because as I said before, at the beginning, they were regulated only the legal entities, and later they included also undertakings and natural persons. So I think that would need to see what is the last draft, and of course also the interpretations, the other opinions that we will get from ESMA and from the other institutions in the EU.
Thanks. I think my point being a bit that, the question whether you would need to be regulated as X or not is one set of questions. And then if you come to a yes, then the next question is the Mika license regime allows an operation of that licensed DEX in a way that it actually can function on the market. And That's, I think, the big question to be answered.
If I just may, there is like a very big differentiation, of course, with the centralized exchanges and decentralized exchanges, how they operate. And the Article 62 was problematic from the beginning in MiCA because it says that every exchange, so even the centralized one, would need to settle their transactions daily, which on the blockchain, which is not something that exchanges do. And it would cost, I think, an incredible amount of money if they would actually do this. And this is how DEXs operate. So in a way, it was like, even with MiCA in the first draft, I think there was a confusion of what is the best way to operate, because this seems to be written for DEXs in a way.
Mm-hmm. Yes, please.
One of the downsides I see, MiCA regulation actually stand from a pan-European framework makes sense, and I can see the benefits. But human nature is human nature, right? And what would stop anyone from, what the MiCA regulation doesn't cover is jurisdictions outside Europe, right? So what's there to prevent someone from opening up shop in a jurisdiction outside Europe that doesn't have these regulations? And then you may have transfer of all the things that happen on blockchain, but without accountability. So, one of the things that needs to be done much more efficiently is that, yes, you're applying us to do the best practice compliance and the best practice regulations, but you won't have a level playing field worldwide, and opportunities will be taken and risks will be taken elsewhere, and behavior is such that you will create that landscape of people diverting the rules. So, you're applying the best standards for us, which is fine, and I think that's the way to do business and do business with integrity. But then we need to make sure there's an international framework of having a level playing field across all channels. Otherwise, we lose the competitive advantage in Switzerland.
Thank you very much for the question, and I can speak out of experience because Liechtenstein is the example for that. We issued a very, very comprehensive framework where you have 11 service providers, where you have to get registered before you can start your business. And the fear was exactly that. Why should we do that? Everybody will move to Switzerland. You need a registration in Liechtenstein. Why would you ever do that? And you're locked in Liechtenstein. 38,000 inhabitants, that's your local market, 160 square kilometer. But the thing is, what happened is exactly what you briefly touched on. We had in 2017, in 2018, in 2019, we were flooded by requests, right? It was incredible, like the amount of requests we had. That changed since the enforcement of our local regulation. And the question is for which reason, and if you compare it to other jurisdictions. But I think one reason also is that it was pretty clear that you cannot operate without having a dialogue with the regulator. You have to apply for it. They will check your documents, right? And this, like the quality of requests we have now is a completely different one, right? And I think, yes, there is like less requests, but overall, I think the quality of growth was a way better one. And that is a legit question, right? We will lose business in Europe for sure, because they will say, yeah, we will do it somewhere else. We will operate out of another area and not in Europe. But I think long term, like the major places will adopt regulation, and I think we should, and that's what we did here as well. We said, nobody will care about the Liechtenstein example if it's not a good one, and we have a same level of regulation in other big areas, right? So my goal, my personal goal, was always to say, please do good regulation, do good approaches on a global scale, because that's a global world, right? Even not a Swiss regulation is helpful, or a European regulation. We should have, like for the entrepreneurs, being able to use the technology to innovate, to make things more efficient, and not being stopped by any regulation, right? But I think that's the big goal. That's what we are working for. At least we are on a daily basis, but that's a long journey.
Yeah. And maybe to add on that, Thomas, what I'm curious about, currently, we have all those different local regulations. We have the Swiss one, which actually is also a regulation, Liechtenstein, some other jurisdictions, and most of the operators within those jurisdictions, they rely fully on a non-reverse solicitation model. So basically, they provide their services on a global basis. Outside of jurisdictions, you're a bit more careful, in particular in some jurisdictions like the US, where you have a very high degree of extraterritoriality in enforcement. So the same logic will be applicable in MiCA. So if you market your services if you target the European Union as a customers, you're going to be subject to those regulations. And the question will then be, well, on the enforcement side, what does targeting mean? What does market into mean? How much will you be able to rely on reverse solicitation as a Swiss company working with European customers? And if I look at that today, and then I'm curious your thoughts, currently in the European Union, we have many countries, we have totally different kind of way how to understand these reverse solicitation models. We have Germany, who, like BaFin, they come in quite quick. Others, they don't care. What do you expect on the MiCA level?
So that's a very curious question, because lately there has been some groups within the trilogue negotiations very much talking about reverse solicitation and trying to enforce maybe a stricter rules that we have within MiFID II. That might not be done through the draft directly, but maybe some of the ESMA recommendations. So the question is, we cannot prohibit reverse solicitation, but the idea there was, even recently ESMA issued an opinion. When Brexit happened, a lot of firms that were not registered within the EU basically put in their terms and conditions saying, oh, if we serve our customers outside of the UK, you are basically agreeing that that was through reverse solicitation. And so ESMA said that's not correct, so we would monitor closely those processes. And this is what also happened here. There was a discussion about maybe through ESMA being, trying to do more reporting or looking into how those companies are doing reverse solicitations through maybe advertising, especially as specific countries in Europe are concerned that big companies today, they are already having a lot of, I would say, users in Europe, but they are not regulated here, and they are not maybe, advertising directly, but still it would be very hard for newcomers that are going to be, I would say, based in one of the European Union countries to take over those users.
Okay. Thank you, Marina. I understand from Nikki, she already gave a couple of signals that our time has ended. I think we could continue discussion forever. Not forever, but a couple of hours at least. But many thanks for Marina and Thomas for the insights. Many thanks to the audience for participating. We're going to be here for a couple of minutes in case additional questions arise. I saw a couple of hands in the area, so we'll be happy to try to answer those.
Yes, as long as you don't mind taking a cut of your lunch break, I guess you can keep continuing on. I just wanted to give the signal that our time is up, but if you would like to answer more questions, it's possible.
Oh, okay. Yeah.
Yes, I will give this to you, then the chocolate at the end.
Thank you.
Did you want to ask your question? I think.
My questions are always complicated. You, Marina, had began to talk about the possibility of regulation from a mechanical perspective, and I'm paraphrasing. And my question had to do with the requirement in Switzerland to register as a VASP would be triggered if, let's say, we, as a company based in Switzerland, deploy a smart contract that's used to perform a series of functions or to provide a return on value. What I gathered from you, Andreas, was if it can be proven that we threw away or destroyed the key of the deployer, then we would not be subject to being regulated as a VASP. Am I correct or incorrect?
I would say incorrect. To the short answer, the long answer would be it will depend whether you keep ongoing business relationship with those customers. So you would on one hand have an infrastructure allowing peer-to-peer transactions, I assume, in your example. So we can tick that box. You would no longer create a dependency on the technology because you throw out the key, so everybody will continue to be able to use that infrastructure forever. And the key question will then be, well, do you keep an ongoing business relationship? Do you kind of somehow have kind of user profiles, user accounts, which you maintain anyway, which are connected to that infrastructure? So I think those questions would need to be answered and looked at a bit more in detail.
Thank you for that.
Yes, maybe all in the back. And by the way, we don't want to keep you locked in here, really not. If anybody's hungry, you're very free to leave. It's on a voluntary basis. So.
You already killed the duck, now it's time to eat it.
Yeah,
Thank you so much.
Thank you. Yeah, please.
Hello, thank you very much for the talk. It's been really riveting and interesting. My question is more to do with custody and how that's been, I guess, explained in MiCA. Because I know member states tend to have a different sort of link to property and ownership, and I'm just curious as to how that plays out in the MiCA legislation so far.
So custody is a service that is regulated as a crypto asset service provider. I can call, it's basically the custody and administration of crypto assets on behalf of third parties. This is how it is defined, and it's basically regulated in MiCA.
But what does that mean for, what does that mean on a localized basis?
So basically, this is going to be a regulation, which means that it's going to be directly applicable. There is no, it's not a directive that would need to be translated in the local jurisdiction. So basically, this is going to be the rule that is going to govern the EU market, and all the member states would need to apply it in the same way. This is what I said before. We know that some of the similar rules have been already adopted in France, Germany, and some other countries. And I even know that some jurisdictions right now are waiting with their planned regulation just because, and laws, because they're waiting for MiCA. It doesn't make sense for them to come up with something new right now because that would be directly applicable.
Marina, I think what is also very interesting, you see that they have a different level of regulation in some European countries already when it comes to custody.
Yeah.
And basically, I'm not a German lawyer, so it's just what I heard, so it's not legal advice. But that you almost have to be, you have to be a bank in Germany to provide, if you're not under the grandfathering, to provide custody services, right? And I think what is going to be very, very interesting is when MiCA is in force, what the level of regulation will be when it comes to custody in Germany, right? Mm-hmm. Because that's going to be an unfair, that's really a disadvantage, would be for Germany if it's that high, that level of regulation.
But don't you, in Germany, you have this Kryptowerteverwahrungsgesetz with this particular license, which also already today has this extraterritorial kind of focus. When you say whenever you have German customers, you need a license, even if you're in Switzerland, but actually, to be honest, nobody really has that license. If you're not sitting in Germany. So I think we're going back again to this reverse solicitation model and the question of enforcement. And my take it is, even if MiCA applies, it will take quite a while until we're there and have those regulations. So let's say 2 more questions, and then we're going to be here for a minute, and you are free to go to lunch.
May I just comment something? The grandfathering clause is going to be very important for all the companies that are already regulated.
Okay, so you already had a question, so let's pick someone who didn't, maybe you, all the way in the back, and then, yeah.
Hi, I'm very interested on this fine line between active solicitation and reverse solicitation.
Well, yeah, we all are.
Yeah, especially as you know, it's quite difficult to cut off a line, especially when you're available online. It's always a big problem.
Yeah,
So
it is.
wouldn't you think that in the end, laws and regulations need to adapt also to the marketing industry? Apart from as an advertising of financial products, of crypto, because it is clearly evident that there's a gap which needs to be well defined. Because from my experience with different jurisdictions, there are totally different standards. Saying from
Yeah, I think that's an interesting thought. My personal take on that is, I mean, we have laws and regulations, and they define a scope of applicability. And certainly, marketing is also depending on what you regulate, something which is already, as of today, being addressed. But on the other hand, on the enforcement, you have regulators which may or may not feel responsible for particular activities, which may or may not have the resources to go after certain activities, even if they would like to. And this will continue to be the case, I think, forever. Independent of the law and regulations you have, you're always going to have someone sitting in an office somewhere and having a pile of work and say, well, which pile should I look at first? Should I look at the one of the companies in, I don't know, Singapore who provide a service into Germany, or should it rather be the company sitting in Germany itself, which is a bit more easy to correspond with? So I think this situation you're not going to change, and this situation always has a high impact on what you understand, what reverse solicitation means in practice, and not only in theory.
Just to add, marketing is regulated in MiCA, especially when there's an issuance of tokens, where there needs to be a white paper drafted, and it's very detailed what needs to be put into a white paper and how this marketing should be done or could be done.
Sorry. Martin, if I may first have the question. You wanted to comment? Okay.
Okay, first off, thank you for your time, but even after sitting here, it sort of feels like an impending prison sentence because it's such a growing field. Sometimes, especially as growing a business here, we're building an airplane in flight, but we're trying to regulate it when we just discovered the equation for lift. And I've come from Germany, and we have BaFin, and it doesn't stop. We had Wirecard failure, Deutsche Bank failures. What feedback mechanism will you have to readjust the MiCA regulations, say, hey, this doesn't work, or the industry's changing, so the law needs to change too? That's the first question. Second question is what competitive advantages does this have for Europe for us to stay here and grow our business? Thank you.
So I'm not sure I understood the first question, but when it comes to competitive advantages, I think they are different for different companies. Depending on this, what is the service you're offering, and what is the level of decentralization you have in your company? This would be my answer. In a way, this is similar to the GDPR. There is this thing that is called the Brussels effect, that regulators in Brussels, they tend to do regulations very early and thoroughly, and then their hope is that others would pick up. We have seen this also, again, in these discussions with the European Central Bank, talks addressing US, etc. So I think that just in general, regulation is coming everywhere. The thing is that the EU has started very early in 2020, and maybe one thing that we have as an advantage here is that we already know how it's going to look like in 2024 in the EU. We're not sure how it's going to look like in the US in 2024, because at least from my perspective, things tend to be much more flexible there and way faster. I think the advantage would be having the same regulation all over Europe when it comes to crypto. And then compared to other countries, I might be critical, but right now, yeah, MiCA seems to be the toughest one of the existing ones today. But we don't know what will happen in the future.
And Marina, maybe just one thought to kind of pick up the line of Thomas before. For me, what has been missing, I think that was also part of the question, is a bit, but not being a non-UA lawyer, maybe I was not involved enough, but it was always a bit the discussion, what should be regulated, and less how should it be regulated? And I think this essentially would be the key question to ask. Now, we currently, in Switzerland, we have this discussion on a regulatory level, which is still in an early stage, about how to regulate the future of asset management in a digital asset space. And one of the elements we currently know, we need a custodial bank to hold those assets. And we all know, or most of us in this room, I assume, know, when you kind of shift from a traditional style of asset management into a digital asset style management, you can replace the custodian by smart contracts performing this function in a very efficient manner. And so the discussion now is, well, how can we change the regulations to eliminate this necessity of a custodian? Should we do that? Should we not do that? And those are questions which make a lot of sense. If you look in the future to say, well, we have a new kind of technology, how shall we change regulations? It's not about licensing and regulating technology, but looking, well, can we change our regulatory landscape to benefit from that?
And that's exactly what I said, which is happening on a European level for financial instruments. You don't need the custodian anymore, right? And that's really huge. That is huge. That will change the way how the financial market is organized drastically, right? It starts with a pilot regime, but that's a huge signal. Yeah.
All right, Martin, last question. Great question.
Yeah, so there's going to be, yesterday there was one trialogue, there are meetings happening every week, but they're big political ones. And the last one is going to be in June, probably. So the biggest, I would say, political agreement would be reached within the French presidency. Then within the Czech one, there's going to be technical discussions, and the finalized draft probably at the end of the year or the beginning of next year. And then depending on the draft that will be accepted, because there are different suggestions at the moment, there could be 24 months or 18 months or even less months until this is applicable then at the end. So probably 2024.
Okay. Well, I think we're going to end here. Many thanks again for participating so actively as well, and many thanks for kind of voluntarily, I have to really underline that, kind of decide not to go to lunch earlier. So it was a big pleasure to be here. Thanks, Marina, Thomas. Thank you, everybody.
Thank you.